Good morning. I'm Gary DeWaal, and this is Bridging the Week for March 24th to 28th, and today is March 31st. This week, litigation and enforcement matters take the top billing in matters impacting global financial services firms. Among other things, the U.S. Commodity Futures Trading Commission fined two different entities of one global investment bank for violating its rules related to the handling of customer funds and position limits. In addition, a high court in the United Kingdom struck down a proposed rule of the London Metal Exchange aimed at helping lower prices of aluminum worldwide, which some have claimed have been artificially inflated because of long waiting times or queues at warehouses to retrieve the widely used commercial metal. This week marks the effective opening of the Major League Baseball season in the United States, so without further ado, let's get going and play ball! Last week, the United States Commodity Futures Trading Commission reminded Futures Commission merchants that it had a zero tolerance for even inadvertent deficiencies regarding the handling of customer funds, even when such mistakes cause no harm to any client. It likewise reminded traders that even short-term position limit violations might be punished too. Both reminders were issued in CFTC enforcement actions against two different Morgan Stanley entities. In response to the CFTC enforcement action against it, Morgan Stanley Smith Barney agreed to pay a $490,000 US dollar fine after it transferred by mistake on April 8, 2013, $16 million US dollars from a specially protected bank account related to its customers' foreign futures and related options trading, a so-called secured funds account. This transfer resulted in a one-day deficiency of a little over $9 million US dollars in the amount Morgan Stanley is required to maintain in all its secured funds accounts for its customers. Morgan Stanley discovered its error itself and corrected the deficiency on the very next day, April 9th. It also promptly self-reported its error to the National Futures Association and the CFTC. In addition, after this episode, Morgan Stanley voluntarily retained KPMG to review its policy and procedures related to its handling of its secured funds accounts, as well as accounts with funds of its customers trading domestic futures and related options, so-called segregated funds accounts. Morgan Stanley acknowledges the CFTC has substantially implemented all recommendations subsequently made by KPMG. Talk about no good deed going unrewarded. The CFTC also found some other minor violations by Morgan Stanley in 2012 related to its handling of customer funds, but acknowledged that none of the failures resulted in a customer loss. However, says the CFTC, quote, "The violations demonstrate a lack of adequate internal controls and a failure to diligently supervise the handling of matters related to Morgan Stanley's business as a commission registrant." End of quote. In a separate CFTC enforcement action against Morgan Stanley Capital Markets, this firm agreed to pay a $200,000 US dollar penalty for violating the all-month Chicago Board of Trade soybean meal futures contract speculative position limit on 3 days in January 2013. After Morgan Stanley first realized it exceeded the all-month position limit on January 14th, it self-reported its violation to the CFTC's Division of Market Oversight. However, the firm did not successfully reduce its position to below the relevant limit until January 16th. Both these matters must remind firms that it's imperative to dot the I's and cross the T's without exception when it comes to complying with CFTC rules regarding customer funds and position limits. However, perhaps it's also time for the CFTC to consider revising its sanction guidelines last updated in 2007 to deal with these types of offenses where the firm makes an inadvertent mistake but tries successfully to correct its problem. Check out what I have to say on this matter on my website. The London Metal Exchange's efforts to reduce the price of aluminum worldwide was dealt a significant setback when the High Court in London ruled last week in favor of a challenge by United Company Recapture plc. After a public consultation, the LME on November 7th last year proposed a rule that would link the amount of aluminum any LME warehouse could accept for storage to the amount of metal it released whenever the warehouse could not process requests to release metal from storage in less than 50 days. It was hoped that this proposed rule would shorten a widespread backup in aluminum deliveries from LME-approved warehouses that critics had claimed artificially raised the price of aluminum and ultimately aluminum products sold to commercial clients and consumers. This was because of the storage charges assessed by the warehouses, which accumulated over time. Russell, an aluminum producer, challenged the consultation process, however. The company claimed that the LME proposed rule would financially hurt producers like itself and never adequately considered this potential harm as it was required. The company claimed that other alternatives, such as limiting the storage charges that warehouses could assess on stored aluminum beyond a certain number of days, would also reduce the price of aluminum without harming producers. The court sided with Recapture. The LME's proposed rule was scheduled to take effect this week on April 1st. Guess what? It won't. A U.S. federal district court judge in New York City on March 24th rejected the efforts of 3 former principal MF Global Holdings officers to dismiss a lawsuit against them by the MF Global Litigation Trustee. The trustee had alleged that John Corzine, Henry Steenkamp, and Bradley Abelow had breached their fiduciary duties of care and loyalty to the company. The defendants justified their motion to dismiss, claiming, quote, nothing happened to MF Global which a single one of the defendants could possibly bear any legal responsibility, end of quote. The judge, the Honorable Victor Marrero, held that the defendant's motion was premature at this point and that the trustee's complaint was adequate to proceed. These motions keep being filed and the judge keeps getting angry, but meanwhile all the US-based customers of MF Global still have not received their funds that were seemingly promised them by the end of last year. Very, very sad. On March 19th, a U.S. federal appellate court in Chicago ruled that funds paid to FCStone, a futures commission merchant, just prior to and after the insolvency of Sentinel Management Group on August 17, 2007, should not be returned to the bankruptcy estate. A U.S. federal court in Chicago previously had ruled that funds paid to FCStone from the failed company should be returned. Sentinel was an investment management firm that claimed it specialized in short-term cash management for hedge funds, individual, financial institutions, and FCMs like FCStone. Allegedly, as it began experiencing financial difficulty in 2007, Sentinel improperly commingled securities purchased with its different types of customers' funds. Ultimately, Sentinel paid its FCM customers, like FCStone, with the proceeds of some of these securities just prior to the firm's insolvency filing, and then, right afterward, the bankruptcy trustee authorized further payments to FCMs. The district court required FCStone to return the paid funds, saying otherwise the class of FCMs would unfairly receive a preference over other customers that deserved equal protection. The appellate court reversed the district court's decision. Separately, the former CEO of Sentinel, Eric Bloom, was convicted last week of defrauding customers of more than $500 million in connection with Sentinel's collapse. And finally, the Financial Industry Regulatory Authority fined Boston-based LPL Financial, a registered broker-dealer, $950,000 for failing to maintain an adequate supervisory system from 2008 through 2012 related to its sale of alternative investments. Specifically, FINRA alleged that during this time, the firm did not have reasonable systems or procedures to identify and determine whether purchases of non-traded real estate investment trusts, oil and gas partnerships, business development companies, equipment leasing programs, real estate limited partnerships, hedge funds, managed futures, and other illiquid pass-through investments resulted in customers' accounts being inappropriately concentrated in alternative investments, contrary to the firm's own suitability standards, as well as applicable prospectus and state requirements. FINRA claimed LPS also did not adequately train its supervisory staff regarding such suitability standards. See what LPS had to say in its own defense in a unique attachment to the FINRA matter. This is on my website. Well, that's it for the principal stories on this week's Bridging the Week. As always, there are more details to each story and more stories on the article version of Bridging the Week on my website. Check it out. For those of my friends and industry colleagues attending the 46th annual SIFMA Law and Compliance Conference in Orlando, Florida this week, enjoy the sun and say hello to Mickey Mouse and the Little Mermaid for me. For the rest of you, have a great week and see you next Monday. And again, practice your singing of Take Me Out to the Ball Game. Ciao.